Yesterday, the Florida State Supreme Court issued a ruling that will allow the 6-week abortion ban, which I'm sure you've heard of by now. The Florida legislature passed that last year. It is now, the door is open for it to take effect beginning May 1st. This represents an effort, literally decades in the making, an effort to try to reverse a previous decision by the Florida Supreme Court that allowed abortion due to a privacy clause that was in the state constitution. So no question, this decision is a major, major win for life. But the court, in another ruling, also allowed a ballot initiative to move forward this coming November, when voters will be able to decide on a state constitutional amendment that would allow abortion up to 24 weeks of pregnancy. Now, because this is a constitutional amendment, it would require 60% of the voters in order to amend the state constitution. But joining me now to unpack all of this for us is Matt Staver. He, of course, is the founder and chairman of Liberty Counsel. He has been very outspoken to the Florida Supreme Court on both of these cases. Matt, welcome back to Washington Watch. Always great to see you.
Thank you. Good to be with you, Jody. You're exactly right. We had these two decisions from the same court on the same day. One that was a culmination of 35 years of work beginning in 1989, when the activist liberal Florida Supreme Court at that time twisted this 1980 constitutional amendment that had nothing to do with abortion, but was about documents and privacy of your documents to apply to abortion. For 35 years, we have worked to overturn that decision, filing an amicus brief as far back as 1989 on that same case. Great decision, finding that there's no right to abortion in the Florida Constitution, upholding the 15-week abortion ban, and then allowing the 6-week heartbeat law to go into effect in the next few weeks. Amazing decision, huge impact. But on the same day, in a 4-3 decision, the same court allowed a Planned Parenthood-backed abortion amendment to go forward if they can get enough signatures to certify it on the ballot in November. And that abortion amendment, it's actually even more extreme than allowing abortion up through 24 weeks. It allows no law, none at all, from the moment of fertilization until viability, which could be late second, early third trimester. No law will be allowed to exist, not even health and safety regulations. But beyond viability, if there is a late-term abortion law that is passed, then a healthcare provider can override that by a veto, simply saying that it's necessary for the health of the woman. Now, who is a healthcare provider under this amendment? About 58 different categories, which includes non-medical personnel, such as a 911 operator, a massage therapist, an orthotic shoe fitter, the assistant to the orthotic shoe fitter, a tattoo artist, and the list goes on and on. No medical training. They'd be able to give medical opinions under this radical abortion amendment. Therefore, really, no abortion would be prohibited through all 9 months of pregnancy, up to and including birth, if this passes.
So abortion would be permitted all the way through. Why did the court make that decision? I mean, if you're talking a tattoo artist and some of these massage therapists or whatever, to have that kind of authority, why? I mean, anyone could look at this and say, these are not medical professionals even. Why would the Supreme Court say, yeah, these people can make this decision? Do you have any clue what drove them to allow that initiative to move forward in November?
Well, you know, the 3 dissenting justices, all females, issued a great dissent. They pointed out the fact that this does not comply with Florida law because a voter initiative must not be deceptive. It must be very clear so that when you read the ballot summary, you know what you're voting for when you say yes or no. It has to be very clear. And they said, no, this is far from clear. It is confusing. It is intentionally vague. It does not apprise the voter of the impact. No voter would know or have a clue that no abortion would be permitted. No voter would even suggest or think that a tattoo artist could determine viability, or even if the baby is viable in that non-medical opinion, then that abortion is still necessary. They wouldn't be thinking about that. They also found that it violated the single subject rule because it disables all three branches of government, because it does not allow any law protecting abortion clinics from regulation, or women, I should say, from abusive procedures. There's no even health or safety regulations that will be allowed. So they got it right. But the other four is just amazing, because I was there. I presented part of the oral argument at the court, and the Chief Justice really got the concern nailed down. He said the voters aren't being informed that this law can impact other existing laws that recognize the humanity of the unborn child. Laws that are criminal, civil, wills and trust, guardianship laws, they all say, quote, the unborn child or unborn person has legal rights. And it could impact Article 1, Section 2 of the Florida Constitution. He brought that up, that it says natural persons have the right to life. This could impact the unborn, and clearly the voters are not apprised. But then in his adjoining of the other three to make the four-member majority, he recognized those concerns, but said, they're possibly hypothetical. We don't know exactly the impact, which is the problem. If they don't know the impact, then the voters don't know the impact. And that's the problem. And that's why it should never go forward. You should know exactly what you're voting on. But on the other hand, the one silver lining is between the number of justices that commented, the three dissenters and another, that Chief Justice in the majority, to make a majority, clearly opened the door, the dissenters clearly, and the Chief Justice clearly, to the idea that we could bring another challenge to have the court rule on the personhood of the child based upon the Florida Constitution itself. So that's certainly a door open for any future challenges if this passes.
Wow, Matt, a fascinating day that took place yesterday. Myself, all of us, we say thank you for the incredible work that you've done, Liberty Counsel, standing in the gap on this critical issue. Thank you for coming on the program and unpacking all of this for us as it moves towards November. No question we'll be looking to you for some more answers. Matt Staver, Liberty Counsel, thank you so much for joining us.
Thank you, Jody. Good to be with you.